So basically what you'll see if you scroll this is they're answering the complaint, and you're just going to see a lot of copy-paste. Defendant denied.
Yeah, that is not at all strange.
This one says contains legal conclusions which no response is required. Just basically not saying anything. Number 16.
Basically, okay, no, it's not saying nothing. It's responsive answers selected based on the content in the actual complaint. So it's not saying nothing, you fucking idiot.
Deny. That's the Hasan form. Look at all this. Look at this copy pasting.
Oh my God, look at this. Look at this. Look at how he's making a big deal. Like, oh yeah, of course, it's an answer. Did you even check about what a typical answer looks like before you made this entire video?
And each and every cause and action set forth fails to state facts sufficient to constitute a cause of action upon which relief can be granted. Copy paste. This is their defense.
Yes. Yeah. That's what happens. Read an answer.
That is essentially a confession, a concession.
It is a confession. It's a confession, he says. Because you didn't move to dismiss, it's a confession. Deranged. Now, you might win on everything because you have a strong case for infringement, but that doesn't mean that it's not any less soy for you to do this kind of shit. And for everyone to talk shit about me because I bring it up and because I actually do my job, and the only thing you get in response is, go suck on Hasan's nuts. Hey, folks, please like, comment, and subscribe. And make sure to check out my newsletter. Information is in the description. But I did want to just real quick comment on something I said on Twitter. You guys probably know what I'm referencing. So it's what I had to say about Ethan Klein's response to Denim's answer. And I said that I would, after Ethan Klein accused me of being like no better than this guy Mike from PA, I took an interest in this case. And I want to report on it. I want to talk about it. I want to give my legal commentary, especially because I think a lot of the legal commentary on this has been particularly biased. I, on the other hand, I kind of pride myself on giving even-handed criticism, fair criticism, always fair. And I like to do that. So I want to restate my position before we get into the actual debate, which is that it's a strong case for infringement. I've always said this, that I think the complaint is unhinged, notwithstanding that it's not dismissible, readily dismissible, because it states a claim upon which relief can be granted. And also that the initial rationale that Ethan gave, that somehow he was going to protect the React community by imposing a standard that would, for example, protect individuals from corrosive lawsuits from Sony and Disney, that argument or that purported motive did not hold water, wasn't true. Was false.
This is not a healthy environment, and with people like Hasan reacting to entire TV shows on stream, my fear is that Sony or Disney comes along, sues everybody, and sets a devastating precedent that could endanger our entire field.
That's been my take. I think it's a pretty rational take. It's supported by the evidence. I provided additional commentary recently to sort of assess some of the purported defenses that Denims could raise. I've been frankly a little bit down on them because I don't know if they're the strongest possible doctrines that she could bring to bear based on like my knowledge of the statements made by Ethan. But those doctrines include abandonment, forfeiture, waiver, acquiescence, explicit and implied license. And we've talked a little bit about those doctrines and ways in which she might marshal a defense pursuant to those doctrines. So I've been following along. I've always had an interest in copyright, but the response has been unhinged as usual to what I think is a sober and even-handed analysis. And the response is something like, why are you focusing on this? So there's no actual dispute about anything I'm saying. It's just a question about why are you focusing? It's about focus. Why are you focusing on this? Well, I'm going to focus on things that people say, about this case. And if Ethan Klein chooses to make a preposterous video in which he says what his intent is, which is to protect the React community, and that is playing in people's heads as that this is a reason why we should support the lawsuit because legally it could protect the React community at some point, I'm going to be like, hey, as a legal commentator, given the factors in fair use analysis, given what a judge is likely to do, given the litigation realities, this is very unlikely to result in precedent which is limited in the way that Ethan Klein suggests. That's called legal commentary. That's called giving a take on law and a perspective. And that perspective is worth listening to because I'm correct. And everyone who I've talked to who comes on looks like a fool when they try to dispute that notion that, oh yeah, it's just limiting to intentional siphoning. So Ethan Klein releases a video on this topic. If Ethan Klein says that my legal analysis is faulty, why wouldn't I keep an eye on this case? Keep an eye on what he's talking about? Why wouldn't I analyze whether his statements are accurate and correct? What would be wrong with that? Should I just not cover this anymore? I shouldn't cover this anymore because Because why? What's the argument there? And when he says some profoundly incorrect things about basic civil procedure and about the litigation practicing and lawyering, I'm not supposed to comment on it. We're supposed to just go over and be like, yeah, this is ignore it. Why should I ignore it? So I'm gonna walk you through this in the next 10-15 minutes. Not super long video. We'll put it on 1.25, and I'll give my legal analysis of why he's incorrect and what he's incorrect about. So let's put it on 1.25.
Guys, another video. Today we'll be discussing Denims and Casey Tron's response to my lawsuit, which was due on Friday of last week. They did respond, and I'm going to go over it for you guys now. And I'm just going to put it this way. This is just a total flawless victory for us. That's how I'm seeing it, and I'll explain why. So here's the filing, and I'm only going to show Denims because they have the same attorney, and Casey Tron's was nearly identical to Denims. So I'm just going to look at hers.
So first off, painting this as a total flawless victory, it's an answer, okay? An answer in its very nature is not apt or not likely to result in great elaboration of one's defenses. It's very predictable why Denims did not pursue a motion to dismiss here. It's because the complaint states a claim upon which relief can be granted. We'll get into some of the other things that Ethan says here, but the mere fact that someone has answered a complaint is not an admission of fault at all. It's not an indication necessarily that the defense is weak. Now, I happen to think it's a strong infringement case, but just because someone chooses not to do a motion to dismiss, it doesn't mean that the case is strong or the case is not frivolous. Now, again, I'm not saying the case is frivolous, but that's just because someone answers as opposed to choosing to do a motion to dismiss doesn't entail that. Especially this case where if you accept the facts of the complaint and you're supposed to take all inferences, reasonable inferences in favor of the non-movement of the person pursuing the complaint, if you take those factual inferences, of course it states a complaint upon which relief can be granted. So it's not super surprising. I haven't heard of any jurisdictional flaws about what, I think that Denims lives in California, and so presumably should be subject to general personal jurisdiction there. And of course, the federal courts have jurisdiction to hear copyright infringement claims. They probably selected the right venue, and so I'm not aware of any defects that would be other basis for dismissal. I think that they were all served correctly. So I don't know why we should read into that, other than the fact that the complaint states a case upon which relief can be granted.
It represents both. So basically what you'll see if you scroll this is they're answering the complaint, and you're just going to see a lot of copy paste. Defendant deny.
Yeah, that is not at all strange to do copy paste, deny allegation, deny this, lack sufficient knowledge to make a claim as to this. This contains legal conclusions. The document speaks for itself. These are form documents. When you do an answer, you have to pay close attention. Thank you so much for the donation. You have to pay close attention when you're drafting the document to make sure that you're not, because these are legal, they have legal consequences. So someone is carefully going through the complaint and looking at what it says and making the correct form statement to apply to the respective paragraph. So it's carefully done. You have to be very careful not to accidentally admit stuff, but the actual substance of the answer is going to be form. It's going to be just copy paste. That is not surprising at all. And for him just so you know, he is trying to convince his audience at this point, and this is where a legal commentator might step in and talk about something and say, actually, and correct the record. He's trying to convince him that, oh my God, they copy pasted. Hey, copy pasted, everybody. Oh my God. So that's what I'm doing here to say, hey guys, it's actually not crazy. This is actually, you shouldn't read into the fact that it's copy pasted to see that they're lazy or something, which is the kind of implication that he wants to give. Is there something wrong with that? Is there something wrong with a legal commentator taking a look at some statement or some conclusion that someone else, perhaps a layman, is saying and saying, hey, you can't actually read into that. That's actually not a big deal. What's wrong with that? You tell me.
Paragraph 6 contains legal conclusions with no responses required. Lots of copy pasting. It's all very just formal kind of.
It's all very formal. Yeah, it's a legal document. It's a pleading. It's a responsive pleading. No shit, it's a little formal.
Saying as little as possible. Answer
saying
paragraph.
As little as, yeah, why would you say more than what is absolutely necessary to say? Not everyone is like you, Ethan, that's going to put pictures of Hitler everywhere when it's not needed. Why would you say more than you need to say? There's nothing wrong with this. None about this is surprising at all.
9 defendant lacks sufficient knowledge or information to form a belief, essentially just saying we can't say.
It's like going and walking a deposition like, oh, why aren't you just answering more than the question that's asked? Why aren't you in a deposition just like saying random stuff? Why aren't you just elaborating in a more loose fashion as opposed to just answering the question that the person running the deposition has given you? Why don't you just like just say everything you want all the time about all your shit. It just it shows and betrays such a lack of knowledge, and really it's misinforming.
Okay, this one says contains legal conclusions which no response is required. Just basically not saying anything. Number 16.
Basically, okay, no, it's not saying nothing. It is denying allegations or saying that they don't have a sufficient basis to form a conclusion, or saying that what the allegation in the complaint is a legal conclusion to which no response is needed. So it's not saying nothing. It's responsive answers selected based on the content in the actual complaint. So it's not saying nothing, you fucking idiot.
They start to move on to defendant denies the allegations. Defendant denies the allegations. They copy pasting.
Yeah. As is your want, as you'd like to do, as you would want to do in a responsive pleading, as you would do in an answer.
I deny. That's the Hasan form. Look at all this. Look at this copy pasting.
Oh my God! Look at this. Look at this. Look at how he's making a big deal. Like, oh yeah, of course, it's an answer. It's an answer. Do you not know what an answer is? Did your lawyer not tell you that before you? Did you even check? Right? Did you even check about what a typical answer looks like before you made this entire video? That's a question you have to ask about, like, what is your actual your process here? Do you check what's typical before you say, oh, this indicates da-da-da-da-da?
It's the same answer between 22 and...
It's the same. Oh my God. Maybe it's because the answer is the same to all of those allegations.
Fucking... Is it the same between 22 and 45, which says answering paragraph whatever 32 in this case.
Oh my God.
Defendant lacks sufficient knowledge or information to form a belief concerning the truth of the factual allegations contained there within. On that basis, denies such allegations. So they copy pasted that monster.
Oh my God. They copy pasted
of a claim. 22 to 24. This is essentially an exercise in saving money, and
it's an exercise in saving money. Can you imagine? So he's saying that they're being cheap for copy pasting the same answer where it's merited in an answer where it's a form document anyway, where it's, by the way, it's not, because the lawyers who had to do this had to spend hours looking at the complaint and correspondingly giving the answer for each of the paragraphs. And you certainly didn't make it easier because your fucking paragraph numbers are unhinged and you include multiple sub A, B, C, sub, and then like little 1, little 2, little 3s. So they took a lot of time and hours to make an answer. An answer doesn't take, like, this took hours and hours and hours of work. It just is not doing a narrative form because it's an answer.
Cutting every corner possible and doing as little as possible, right? That's
doing as little as possible. That's what we characterize it. Doing as little as possible.
Happening
Someone
here.
who has no fucking clue about what a responsive pleading is supposed to look like.
Continue on. More copy pasting. Paragraph 46 to Jesus.
Yeah, this is when your lawyers, I think, inappropriately included a memorandum of law about fair use where you were making a complaint. All right. You were making a complaint and your lawyers made a memorandum of law on fair use, which I think is inappropriate given the context that it's a pleading. And so, yeah, in that entire section where it's a memorandum of law, we don't need to respond to that in the answer because it's not an allegation of fact.
To 63 says identical things. It just says paragraph 46 contains legal conclusions to which no response is required. And they copy paste that, and then they move on to copy pasting here. 65 to 70, defendant denies the allegations. 71, defendant denies the allegations.
He's like, oh my God! All he says is he denies the allegation.
So this is essentially what this continues to be. They really don't say anything in this. Everything is like, I don't.
They do say stuff. They're denying your allegations or specifically responding to it.
No, we don't know. We can't. How can we conclude? We don't know. Just that repeated and copy pasted like 100 times. Here's when they have now the ability to set their case forth.
They have the ability to set their case forth in narrative form. It sounds like someone who's never fucking had an answer before, doesn't know what an answer is, or just as a layperson, probably shouldn't be commenting on it. You're not supposed to, or it's not good practice to, in your answer, do like a narrative about why this fulfills fair use or doesn't fulfill fair use. It's not what the document is for. And this is perfectly fine. Stating those affirmative defenses is so that you don't waive them. And yeah, not all of them are going to be applicable, but you just include them so that you don't waive them. It is not an opportunity to just do a narrative on why you're innocent and why you're the best person ever. That's not what this is.
To explain their defense, they have claimed that our lawsuit is frivolous. Hasan has claimed it. They have claimed it. Everybody who is trying to support them, Ian Idubs has claimed it. They say it's frivolous.
By the way, not me. I don't, like, I'm not here to support one side or the other with respect to like some partisan. I don't have some partisan aim here to support Denims or to some grifting end. I'm just telling you the truth after you slandered me, or not, I don't want to say slander, smeared me as a Mike from PA guy. The only dog I have in that fight is, I guess, some pent up, negative feelings on you saying that. So that's the only like dog I have in this fight. But I certainly don't have an interest right now to just like help Denims.
Why then have you declined to do the minimum amount of work in your case?
So he describes the minimum amount of work is to like elaborate in the affirmative defense section, even though he has no idea what he's talking about.
Explain it. Here.
That's the minimum amount of work. Not having any knowledge. That's his process, is just to say random shit on a stream without any, even to check, right? Even to check, is this what actually occurs in a responsive pleading? And everyone else has to act like this is totally normal, even though it's fucking not. And I'm tired of you guys pretending that it's wrong for me to comment on the legal stuff. Like, fuck that. This is the truth. I'm telling you the truth. And this is an idiotic reading of the pleading.
First, affirmative defense for fair use. Complaint in each and every cause and action set forth fails to state facts sufficient to constitute a cause of action upon which relief can be granted. Copy paste, copy paste, copy paste, copy paste. This is their defense.
Yes. Yeah. That's what happens. Read an answer.
This is their answer on fair use. Plaintiff's claims are barred in whole or part by the equitable doctrine of unclean hands. I'll tell you, the only unclean hands here are yours, bucko. I resent that. That is actually a legal doctrine. I'm just being silly. Yeah, it's just copy pasting. I mean, it's unbelievable.
It's unbelievable. It's so unbelievable they would do the normal thing that everyone does. It's unbelievable. Whoa.
The lack of effort that's gone into this. So that's what it is by their.
This does not indicate, in my opinion, a lack of effort. This is, and especially given that it said what I expected at the places I expected it to. This does not look like AI. This does not look like lack of effort. This took hours to make. Hours and hours.
Attorney. Besides what's written here, the most interesting takeaways are these, and I'll tell you. Kind of as I touched on, one, they did the laziest, cheapest response.
Nope.
And they
wrong. Categorically wrong.
Failed to tell their story. They had a chance.
They didn't have a. This is not answer. Is not for you to just tell your story, and it's also very it's, I think, kind of indicative of where his mindset is. I would say the complaint is definitely a place where you can tell a story, and it is a story that you're trying to tell in a complaint for sure. But he was expecting some kind of substantive legal response to his accusations, and it shows where his mindset is. His mindset is on the narrative. His mindset is on the story, in my opinion.
Chance to respond, and they did not take it. The biggest thing to me is they failed. They had the opportunity to file a motion to dismiss.
They did have the opportunity, but it would have been a fucking waste of time and money. It is not surprising that you're not going to waste time and money. Like, even if you make a shit ton of money, you're not going to waste time on a motion to dismiss when, yeah, it could be the case that your case is still frivolous. I don't think it is. Just to be clear, I don't think the case is frivolous. I think it's a strong case of infringement. But just because you survive motion to dismiss, it could just be that you, plead a case that has sufficient factual, detailed allegations to state a claim. It doesn't mean that your case is not frivolous or the facts aren't there, or for whatever reason there's some legal doctrine as applied or on summary judgment you expect, right? Even you, right? I don't know if you filed a motion to dismiss in the bold guy case, but you did it on summary judgment. That's not at the motion to dismiss stage. A lot of the time, these infringement cases are very trivially going to pass over a motion to dismiss stage. And just saying that you get over the motion to dismiss doesn't mean that you win the case.
This is what you do when you believe you have a frivolous case. You're telling...
See, you don't always do a motion to dismiss when you believe you have a frivolous case if you can't dismiss the case and if it's going to be a waste of fucking time and money. You don't do it. Why would you waste money spending money on filings or spend, like, when you just want to get to discovery instead of wasting time and paying your attorneys to file a filing that is going to be a waste. You're probably going to do legal research anyway on fair use, but might as well just not annoy the judge, not get into, and it's a thing you're going to lose, and then you're going to bandy around the denied motion to dismiss as an optical win. And so I think it totally makes sense for you in that context not to waste time, money, and a potential optical win on a failed motion to dismiss and just get right to the answer and then go right to discovery. What's the problem?
The judge, this is so frivolous that I will just set the facts straight for you, and it's so obviously fair.
Set the facts straight in a motion to dismiss. That's not what a motion to dismiss is for. You don't get to put up additional facts at a motion to dismiss stage. You have to take the facts as alleged, the well-pleaded facts in the complaint. Already shows you're a fucking idiot. You don't know what motion to dismiss is.
Use that we don't need to waste anyone's time going any further than this. They did not file a motion to dismiss, which means the attorney looked at the facts and considered them all, that they all have merit, and that there was
No, that is precisely the opposite of what a motion to dismiss posture would be, is to say, oh, all these facts have merit, that's why I'm not doing motion to dismiss. No, the motion to dismiss stage is assuming the facts, the well-pleaded facts. Do you have a legal case? That's motion to dismiss, not what you just said, which is like literally the opposite.
Way in hell a judge would grant a motion to dismiss. That is essentially a confession, a concession.
It is a confession. It's a confession, he says. It's a confession. Because you didn't move to dismiss, it's a confession. Deranged.
That the lawsuit is not frivolous. Because if it was, they would have filed motions to dismiss. That would have been a no-brainer. They didn't do it.
No, something could be factually frivolous, in which case a motion to dismiss wouldn't help you.
The lawyer said, let's not even do that. Let's save money, right?
Let's save money. No, let's not waste money or time or give you an optical win on a case that's not dismissible.
Chance of winning. So that's interesting. The other interesting thing about this is that they did not file any counterclaims. We were expecting...
Again, for the counterclaims, my understanding is the ones that were bandied about
them to try to file counterclaims, which means
they're not mandatory counterclaims. You could bring them in another form that you thought was more advisable. Maybe you don't think that they have much merit. So they're not mandatory counterclaims because they don't relate to the same set of facts. One is an infringement case. The other are statements have nothing to do with infringement. So they're not mandatory counterclaims. You could amend the answer if you wanted to. And maybe those claims don't have any merit. Maybe you don't want to pay for them. There's a bunch of reasons why you might do a counterclaim. But it is true they didn't include the counterclaim. They probably could have, assuming that there's some, the jurisdictional hooks are there.
It would include in the response some ridiculous trumped up defamation or something, just something to give
They're not mandatory counterclaims, and so you can't read that much into it.
them leverage against us to be like, oh, see, now they have to deal with.
I pretty much have to go to this thing now, but just to give you a taste of how deranged this take is. And for me to comment and be like, yeah, this is deranged. It's soy as hell to go on a stream with no research, not having any clue what these legal filings are, what an answer is, and to act like it's a fucking confession that you win on everything. Now, you might win on everything because you have a strong case for infringement, but that doesn't mean that it's not any less soy for you to do this kind of shit. And for everyone to talk shit about me because I bring it up and because I actually do my job and have an even-handed response, in my opinion, even-handed, fair, analyzing the facts in the case. And the only thing you get in response is, go suck on Hasan's nuts. The only thing you have in response are attacks on my character, smears, shit like that, like you're no good, better than Mike from PA. When I'm telling you the facts and no one has said anything to counteract what I'm saying, that Ethan is dead wrong. If it was not that big of a deal, just say, yeah, you're right about this. You're right. It is fucking soy. But they can't do that because of the narrative, because of the in-group preference, that kind of shit. And so that's why I covered it, and I'm absolutely correct. And I challenge anyone to say that what I'm saying here is not completely, totally correct.